Hypocrisy.
Motherfucker. Hey, what's up, guys? Welcome to Law Splaining the Interwebs. I'm your host, Nick Recada of Recada Law, a small law firm in central Minnesota that doesn't know how to use the hardware mute button, apparently. Anyway, look, it's an early stream, even though I'm late to it, which is how you got to roll around here. Got to be late to the early stream. It's going to be a little bit shorter stream tonight. An hour and a half is the target. I've had a very tired, need to get some sleep. I said these night shows are not agreeing with my schedule as of late, but I did want to do a show today. Make sure we get some stuff out there. We're going to hit the topics pretty quickly, and then I'm going to log off. I'm going to go to bed. I got a bunch of stuff to do in the morning. I don't have my normal routine where I do an errand, come back, go to sleep. I got to be out a little longer. So we are going to do that. Look, there is a challenge mode today. Should you choose to accept it, I don't care if you do or don't. It's a short stream, so I don't have any regular liquid down here that's suitable for drinking. I think I just have I got a tiny bit of Gatorade. Oh, wait. I lied. Liar who lies. Here we go. I do have a vitamin water, but this will be used sparingly. Tonight, 1 hour to 1 hour and a half or whatever, it is open season on liquor. That's what we'll do. Every $150, I'll take a shot. But if $0 come in, I will not take a shot. It'll be great. We'll do that. Again, I wanted to add some spice to the show for some quickness, but it's still going to be short. The topics tonight, we're going to hit Clarence Thomas recusing himself from Donald Trump's 14th Amendment disqualification. Everybody thinks he should. And by everybody, I mean nobody who actually matters. And then, of course, Trump's New York case with Judge Engoron is waiting for a judgment. There's a couple things going on. We're going to hit those stories really quickly as well. That's the main agenda. I don't think we're going to have any other topics after that. We're going to get those done. And then tomorrow should be a full show as we go into Thursday and Friday. And then I would love to make up a show sometime this week, but I don't know if I have any time. My days are jam fucking packed. I'm almost never home. It's getting a little nuts. So we're going to try it out today and we'll see what happens with that. Without further ado, Killer King says, still not talking about Vic. Well, I've heard something about an order for Vic to pay, which he already had a judgment. So if you really want to talk about the order for Vic to pay, there you go. There's a judgment, and now he's ordered to pay. Not much. I don't know anything about the case anymore. I haven't been following or keeping up. That's what I got. I didn't even know the order came out until the other day. People mentioned it, and someone sent me something on Twitter. I haven't even seen the document, so I could talk about it, I guess, but I don't know anything about it. Maybe I'll look it up for tomorrow's show. I'm guessing it's just an order to pay with all of the updated fees from the appeals, is my guess, but I don't know. So I'll check it out. Not tonight, though. We're going to do these topics tonight. I'll hit it tomorrow, and then we'll see where we go. So J. Neil Vargas says, what the hell, Nick? Too early. Lol, hi. Hi, what's up? How's it going? IT Goatee says Hawaii gun case. And Shut Up, I Can Cook says, hi. We vacation for me, Nick. Also, can new judge force suitcase murder lady to keep her seventh lawyer? Maybe. It depends. It depends. Jim says, can we talk about the gay ops they're pulling on your buddy Camelot, or is that not allowed? I mean, you can. I just don't know anything about that either. So hold on. So, hold on. Sorry. Give me 1 second. Sorry, things are some weird, not weird in a bad way, just some stuff I have to answer real quick. I'll be right back. All right. Sorry about that. Had to take care of that real quick. Russell Hall says, I thought Camelot was a gay up. Well, yes, he is. I don't know. I haven't talked to Camelot in a little while. I know he's doing his NASCAR stuff on, I think, the 17th or something, but I don't know anything about any gay ops or stuff. I'll have to check up with that. Guys, I've been out of the loop on everything. Like I said, my schedule is way wacky. And people are messaging me right now about all this stuff. I'm going to turn them off because I got to do this show. Anyway, Jesus. I don't know anything about what's going on with anybody, any of the drama. I haven't been following it. I haven't been doing anything with that. I'll try and catch up. 1 second. Oh, God damn it. Hold on. Oh my gosh. Finally. Okay, I'm done. I'm done. Done chatting. Shut up, I can cook, says Nick. It depends on what. This is her 7th lawyer of a few months. She's already writing letters to the judge to dismiss him. Judge said May trial. Well, eventually, the judge can order, I believe, you to keep counsel without good cause to dismiss them. But it depends on a lot of different factors, and it depends on the state. And I don't know all of the facts. I don't know the specific rules of that court or the state there. So I can't tell you. It depends is a very common legal answer. It's not always straightforward. Russell Hall says, I'll summarize. Basically, everything is on fire. Kind of going around there. Hockey VG says, my uncle worked at a very high level in the WWF during its heyday. The stories about Vince and the company in general are absolutely wild. This case sounds 100% par for the course. It doesn't surprise me. Billionaires are hilarious. And by hilarious, I mean eccentric and weird. and you can't understand how they live or what their perspectives on anything is, because their lives are so vastly different from ours. But we'll have to see how the case goes. I'm really looking forward to the release of her text messages, which are likely coming in the answer, if I had to guess, because that's how they're going to go after her, if I have any concept of what they're doing. But I may not. They may have a completely different legal strategy. But painting her as a willing participant who's routinely giving consent seems like the right move. But we'll see. T-Boy Ted says, are you going to be able to cover any trials in the coming months? I want to cover the Courtney Clenny trial, which I think is coming up next month, although it may have been delayed. That's the next one that's like presently on my mind. That's the OnlyFans murder trial, where she claims self-defense, stabbing of her boyfriend. That one doesn't look good for her, but we'll see. She doesn't look good without the filters either. So we'll see how that goes. I want to cover that trial. I'm looking to clear the schedule for it. I was going to cover the Trump Georgia trial, but that one is indefinitely suspended pending the appeal of the immunity question, which the appeals court of DC has rejected immunity for Donald Trump, which means the next step is the Supreme Court of the United States. And that's kind of the way it was expected to go. There is no jurisprudence on the question of presidential criminal immunity. The Supreme Court was going to have to make a new rule about this, and whatever they make will be the rule going forward. So, but until then, they're not going to run the Georgia election fraud trial. So that was going to be televised, but it's now on hold. We just have to see what's going on. All right, let's get into this recusal question for Justice Clarence Thomas. Now, here's the deal. Colorado and Maine have independently executed a Fourth Amendment banning of Donald Trump from the ballots in the state. They said he's disqualified under Section 3, of the 14th Amendment, specifically that he engaged in an insurrection and that his engagement in an insurrection makes him unable to hold further office in the United States. So with that, they have said he's disqualified. The problem with this is the concept of a state being able to disqualify a presidential candidate based on the 14th Amendment with no specific means of Congress or generated by Congress to do so. The states just kind of came up with a plan and said, okay, you're banned. You're banned. It's kind of like Twitter or whatever. It's arbitrary. It's based on something that no one can put their fingers on because there's no rule. There's no rule that exists on this. They just made up a process and then applied it to them. And it's conveniently against a political opponent. So with that, we have this now going to the Supreme Court, and they have to determine if a state or if these states have the ability to keep Donald Trump off of the ballot for the presidential election in 2024 because he engaged in an insurrection on January 6th of 2021, because that's the claim that's being made. So when you break down these cases and the ultimate question for the Supreme Court to answer, it's always good to frame that question very specifically. Does Colorado and subsequently Maine have the power to prevent a presidential candidate from appearing on their ballot when they have determined independently in each of their own methods, Colorado through their court process and Maine through their Secretary of State, using basically acting as a judge, when they have determined through each of their independent methods that that the president has engaged in insurrection as to the meaning under the 14th Amendment. That's the question they have to answer. Can the states do this? Can Colorado and Maine specifically do this in this way? It's that narrow. Now, their answer will probably be more broad than that, but that's the question asked for the court. And it's always critical to try and frame the question as narrowly as possible, because judges may frame their answer as narrow as that question. They can expand it out. They can create a rule that answers more broad questions. They could simply say states don't have the power to do this unless Congress creates a process that allows the states to make the decisions. They could simply say that it doesn't apply to a president. They could do all sorts of different things that would broadly apply and also qualify or disqualify these states. But they may just go to the individual questions that are there and answer them and nothing more. We don't know what they're going to choose. So with that, let's see the issue that is now present as this goes to the Supreme Court. And that is that Justice Clarence Thomas is hilarious. That's the problem that they have now. Justice Clarence Thomas is now being pressured to recuse himself in the 14th Amendment case because of his wife's role in January 6th. Very nefarious sounding, obviously. Ginny Thomas, Clarence Thomas's wife, participated in January 6th in some capacity. She did not go into the Capitol building. She did not organize or plan it, but she was present. So therefore, they're going to try and lay this on Clarence Thomas. Now, the Supreme Court is interesting. Each justice has the independent authority to recuse themselves or not. There isn't like a way to force a justice to recuse himself. There isn't actually any authority over the Supreme Court from the other branches of government other than impeachment is a possible removal of a Supreme Court justice, but that's about it. They sit for life. What do you do about it? Can you force them off of the case? No, not really. Public pressure, public perception of the court's integrity is the main weapon that they have against the court. So now they've been going after Justice Clarence Thomas for over a year now on his ethics issues. His ethics issues in the past have been related to the acceptance of money and gifts lavishly dropped on him by his friend, who happens to be a billionaire, who they say was doing that effectively to curry the favor of Clarence Thomas to rule in the way that Clarence Thomas would effectively rule every single time anyway. But that's the claim. They've been hitting him hard on ethics. And there is now a code of ethics that has been independently adopted by the Supreme Court itself. The funny thing is, the code of ethics is unenforceable even by the court. No other justice can force a Supreme Court justice to abide by its own code. There is no constitutional authority to impose a code of ethics on the Supreme Court. It doesn't exist. So Congress can make a judicial ethics law, and it's not enforceable against the Supreme Court. The Supreme Court can adopt its own ethics rules. It's unenforceable. If you don't like a justice's behavior, your only option is to impeach them. If you impeach a justice, it really starts to look political and like you're trying to free up a little favorable slot for a replacement, right? So they've got this dilemma. They can't do anything about it other than run article after article after article against Clarence Thomas, which they have been doing. Now we're starting to see the threads come together in this particular place, and that is to pressure him again on ethics over his wife's presence in January 6th. So that's where we're standing right now. XIV says, hey, Nick, I'm the guy that gave you a whiskey in Corpus. Oh, hey, what's up, man? Just started college for process technology to try and get my life in order. Never too late to start, y'all. Hope the Legion treated you well. Cheers. It did. I really like that whiskey. Thank you so much. So here we go. Should Justice Thomas recuse in Trump 14th Amendment case because of wife's January 6th role? The case tests the U.S. Supreme Court's recusal rules in its new ethics code. It actually doesn't, but we'll talk about why. So here we go. When all 9 justices of the U.S. Supreme Court signed a new ethics code last year, each pledged to step aside from a case when, quote, impartiality might be reasonably questioned, or when a justice or a spouse has a financial interest in the dispute. So what they're going to say here is that Justice Clarence Thomas is uniquely conflicted on his impartiality, and they're going to blame his wife, even though those two things, the spousal financial interest is where they mention a spouse, but his impartiality being reasonably questioned is not really supposed to involve a spouse at all, but they're going to try and link them. So here we go. That pledge made amid ethics questions involving Justice Clarence Thomas and some of his colleagues. See how they did it? Push, push, push. Story, story, story. Okay, fuck off. We'll make a pledge. Here's our new ethics rules. Oh, now he has to follow them in this particular way that we want, and which is not independently enforced, is now being put to the test in one of the court's most high-profile and high-stakes cases in a generation, ethics experts say. Former President Donald Trump this week will ask the justices to overturn a Colorado Supreme Court decision, which said he had, quote, engaged in insurrection and is ineligible for the 2024 ballot under the Constitution's 14th Amendment. Thomas, the court's most senior conservative, has unique association to events at the center of the ruling. His wife, Virginia Thomas, who goes by Ginny, she's right here, by the way, is a longtime conservative activist and Trump booster who helped lead the Stop the Steal campaign to overturn the results of the 2020 election and who attended the January 6, 2021 rally near the White House but did not march on the Capitol. So here we go. Here's the attack. She's a Trump booster and conservative activist. That's not a financial interest, by the way. And that's not Clarence Thomas. That's Ginny Thomas. They're two different people. There are lots of instances where justices have spouses with specific political alignments that you could say, well, their spouse likes this thing, so therefore they're not going to be impartial. But that's not how ethics rules work on judges. Inspizia Video says, hi, Recusal Law. 20 days ago, I got laid off. That sucks. Next week, I have first interviews with 2 different companies for an engineer. Please pray for me, I guess. Will do, brother. Go get it. Quote, Ginny Thomas was a supporter of Donald Trump's from pretty early on in his campaign, and she's maintained that support even through today. That's perfectly allowable. That is not a conflict of interest. Ginny Thomas isn't ruling on this at all. She can support whoever she wants. Said Gabe Roth, executive director of Fix the Court, a judicial watchdog group. And those attempts to overturn the election was what led to the insurrection, which is what led to Trump being kicked off the ballot in Colorado. Okay, first of all, not an insurrection, in my opinion. Second of all, Ginny Thomas was part of Stop the Steal, which was about that which led to... Did you see the levels of disambiguation that have happened here? The levels of abstraction from the issue that they're having to go through to paint Ginny Thomas as having some interest that would further be abstracted by going to Clarence Thomas, where he is now forced to accept Ginny Thomas's viewpoint on something that's several levels abstracted away from the main issue. This is a stretch, even for a Russian gymnast. The Colorado ruling cited Trump's direct and express efforts over several months, exhorting his supporters to march to the Capitol to prevent what he falsely characterized as an alleged fraud on the people of this country. Leading legal ethics experts say the activities of Ginny Thomas pose a clear conflict of interest for her husband. And here's the immediate problem with that statement. Leading legal ethics experts say, who are they? What's their political affiliation? Democrat. What makes this a clear conflict of interest for Clarence Thomas? Nothing. Ginny Thomas doesn't stand to benefit in any way from the qualification or disqualification of Donald Trump. She has no financial interest. She doesn't even have a political interest in Donald Trump. You can't assign someone some value in a particular candidate being allowed on a ballot. She may be a fundraiser and booster for Donald Trump, but she doesn't have a particular interest in him being on the ballot and campaigning, other than she wants to vote for him. But that's not a particular interest. That's just an interest. There's nothing about it that would create a clear conflict of interest here other than that of any voter. And you can't do that. Quote, this is the easiest recusal analysis case you could ever imagine, said James Sample, professor and judicial ethics expert at Hofstra University Law School. Okay, James, who are you? James Sample. Oh, hey, he looks like a semi-normal person. That's rare. Here we go. I'll pull him up for just a second. I'm actually kind of surprised. He's a guy over here. I'm kind of surprised. Usually these guys look like just pure weasels, but that guy looks semi-normal. All right, back to this. The question isn't, should Ginny Thomas be allowed or not allowed to engage in political advocacy? Sample said. Well, no one asked that question. That's not a question of recusal at all. Concert LD says, but the Supreme Court denied hearing any of the election cases. Let's talk about prepping. Says, what do you get when 2 homosexuals bathe together? Gabe Roth. That was a good one. That was a good one. Holy shit. Damn. S. Nelson 134 says, Nick, what they will do is use Thomas's non-recusal as an excuse to expand the number of justices. They only need a majority in both houses of Congress, and after the Mayorkas impeachment, they can obviously get the votes. Yeah, that's not a far-fetched theory. Expanding the court has been in the cards for a little while now. All right, back to this. The question here is, should Clarence Thomas, when Jenny Thomas engages in that political advocacy, be allowed to rule on the legitimacy or illegitimacy of that advocacy? That's not the question, though. That's not the question, because Clarence Thomas is not being asked to rule on the legitimacy or illegitimacy of Ginny Thomas's political advocacy. He's being asked whether or not Donald Trump engaged in insurrection by his actions. Ginny Thomas isn't accused of an insurrection, inciting insurrection, participating in insurrection, insurrecting against the United States. She's not accused of any of that. She participated in a movement. She has no criminal charges. She barely even has allegations of doing anything other than random statements that she was present in some capacity at January 6th. So this guy's framing the question in a way to make it seem a little bit more nefarious than it is. Obviously. That's what they do. Top Democrats have implored Justice Thomas to step aside. Well, of course they have. They know how he's going to rule on this. There's no way Clarence Thomas says, oh yeah, Donald Trump should be disqualified. No way they do that at all. Or he does that at all. I'm afraid Justice Thomas, through his family, has crossed that line and he should recuse himself so there's no question of bias in his decision. What line did Ginny cross? What she said, I think the vote was rigged. Like that's the line she crossed? Okay, cool. Senate Judiciary Committee Chairman Dick Durbin told ABC News 8 Democrats on the House Judiciary Committee wrote directly to Justice Thomas last month, urging him to sit out the case. Quote, it is unthinkable that you could be impartial, they wrote. Yeah, I'm sure Sotomayor, Kagan, and who's the other one? Oh, fuck. Breyer. I'm sure is it Breyer? Still? I think so. No, it's Ketanji Jackson Brown Jackson. Ketanji Brown. Not Jackson Brown. He would probably rule the same way. It's Ketanji. I'm sure all of them are going to be completely impartial in their analysis. They're definitely 100%. They have no bias, no political bias, no animus towards Donald Trump. That's it. Ms. Thomas has shown a fervent bias in favor of Mr. Trump, and it is hard to believe that her bias has no impact on you. Well, believe it, sisters. That's how the court works. You can't just say a spouse has bias, therefore you have bias. It doesn't work that way. It never has. You have to have direct interests to do that because a mere bias isn't sufficient. Or you have to have evidence that the spouse's bias specifically impacts the justice. You have to show how. You can't just infer it. You can't just say, well, I mean, gotta be there. Justice Thomas has not responded to Democrats' demands and has not said whether he'll recuse from the case, but his defenders say the calls are nothing more than a political ploy. Well, they are. That's it. That's the only thing that it can be, because there's no foundation for what they're saying. There's no basis for it. David says, what if Ginny had put money on Trump through one of the election betting markets? Conflict of interest be more present to the point of a recusal for a normal judge? Yeah, yes. That would be if Ginny Thomas had a direct financial interest in the outcome of this case, the outcome of this question. Like, will Donald Trump be on the ballot? Will he be a 2024 Republican nominee? Things like that. Yeah, that would be a different story. But you'd have to find out if she actually did that. And if Clarence Thomas knew about it. So here we go. Quote, I think there are people who would like to see Justice Thomas not deciding this case, and therefore they're going to attack him, said Carrie Severino, former Thomas clerk and president of Judicial Crisis Network, a conservative legal advocacy group. Quote, you can spin out a crazy story, but why anyone might have some, appearance of impropriety in the eyes of someone who's engaging in conspiracy theories, Severino said, but this has to do with what is a reasonable appearance of impropriety. And yes, again, they have to show why he would not be able to be impartial on this case. Not just because of a political opinion or a political bias. It has to be demonstrable and reasonable. All right, neither the justices nor their spouses are formally bound by the Supreme Court's ethics code. No, you can't bind them. You can't do that. There is no way to bind Supreme Court justices because the Constitution doesn't have a method to do it. That's why the justices can recuse themselves. And each justice gets to make recusal decisions on his or her own. There you go. Very simple. The Thomases did not respond to ABC News' request for comment. Good. Don't talk to them. Several of Justice Thomas's allies suggested to ABC News that he is not likely to recuse from the Trump case. He shouldn't. He has already participated in cases that directly or indirectly involved the 2020 election. In all but one case, he did not recuse. Quote, her activity is her activity, said Severino, completely apart from anything, or completely apart from the fact that she was not involved in anything illegal on that day at all. There's the fact that she is her own person. And that's where it really gets to. That's where it has to go. She gets to be her own person. And the actions of a spouse outside of specific narrow things cannot be imputed onto a justice or anyone else. We've got, let's see, John GTV says, hey, Rackets, can I get a toast for my wife's childhood dog? Oh, Lily, this past weekend, she had to be put down. She lived 14 long years with a family that loved her dearly. She was a great pal. It would mean a lot if you would say a word and give a toast in her honor. I will do so. 1 second. Okay. All right. Okay, let's see. Let's enlarge me to John GTV's wife's childhood dog, Lily. 14 years. The loving family, receiving love and affection, becoming a member of the family beyond just a pet or an item or an object. Beyond any of those things, welcomed into their home and hearts. May Lily pass from their home, but never from their hearts. May she go with peace, and may they always remember her fondly. Cheers. All right. Kate C., a.k.a. Snake Plush Kitten, says, how gung-ho will the Dems be to expand the court if Trump wins and the GOP gets 53 senators in the election? I don't think they do. I think that's a bad political move. Shoot Groomer says, Nick, my son's finally home from the NICU. He's doing fine. Thanks for all the words of encouragement. That is awesome. Thank you for sharing. Again, much hope and well-being for the health of your kid. It's always fucking scary when your kid, especially babies, are in the hospital like that. All right. So we have also hit the first little goal here. So we'll take the rest of this liquor right now. Cheers. Whew. Contrarian 420 says, Nick, we both love 13 Assassins. So do yourself a favor and pay $8 on Steam for Masterpiece Pixel Graphics Samurai game, First Cut Samurai Duel. I'll check it out. I haven't played video games in a really long time, but I will check that out. All right, here we go. Ginny Thomas has said she had no role in planning the January 6th event and that she was disappointed and frustrated that there was violence. This is part of it. How did Ginny Thomas engage in insurrection? In any way? How did she participate? How is she a part of the insurrection? that would then, again, if she were charged with insurrection, for example, if she had an insurrection charge and Justice Thomas's ruling on this issue would somehow show definitively that no actions of anyone there could be qualified as an insurrection under the Constitution's meaning of it, that would be a different story. He would then have an interest in the outcome of that because he would potentially be absolving her of any sort of punishment or prison time. And that's, again, that is different. That is wildly different from what's going on here. But what we have here is just simple advocacy for a candidate that they like, some fundraising, some advocacy on a massive political idea. The Stop the Steal campaign, they want that to be a niche movement of crazy people who baselessly thought something was a massive conspiracy with, like, you know, red lines all over the fucking place on a pegboard. They want people to be painted that way on Stop the Steal, but millions of people believe that the election had significant levels of fraud in it. Millions of people believe that. It wasn't an obscure idea. Was it a majority of the United States? Probably not. Was it a majority of the Republican Party? I don't think it was, but I think it might have become it for at least a while. But they want to paint it as this tiny movement of crazy wackos and Q boomers or whatever who did this, but that's not it. And people's independent opinions about the election, multiple different variations of those opinions fit into the Stop the Steal movement. Now, what happened after that and what they did, that's on them. It's not on anyone else. Okay, here we go. In testimony before a congressional committee investigating the January 6th Capitol attack, Thomas insisted she does not discuss politics or cases with her husband as an ironclad rule. Now, a lot of people don't believe this stuff when spouses or friends or close associates of Supreme Court justices are asked this. They say, well, we don't discuss anything like that. And they're like, come on, you have to. You have to do it. Oh, of course you do. Well, of course isn't really a thing. Of course isn't evidence. It's these people say they don't. Someone who has no knowledge of it says, well, you have to, you must. It's not how this works. But they all do this. It happens every time. Like, of course you must. But guys, I got to tell you something. Clarence Thomas has been a lawyer for a very long time. Lawyers' ethics rules that prevent them from disclosing all sorts of stuff include spouses. Like, your spouse is not exempt from your duty of care to privacy and secrecy of clients. Just because you're married to someone doesn't mean, oh, well, you can tell them though. No, you have to take that stuff to your grave. There's a bunch of stuff I have to take to my grave. Lady Raggets can never know because it's not her place to know. Confidentiality, client confidentiality is paramount. And you can't breach it, even to your spouse. Just can't do it. So the idea that, like, oh, how could Clarence Thomas and Ginny live like that? They've lived like this forever. As long as he's been a lawyer, that's been his rule on various things. The justices have a different set of things that they can't talk about, but not talking about stuff isn't new to them. So here we go. Quote, whether or not Clarence and Ginny Thomas discuss these issues in the privacy of their own personal conversations is not the issue, Sample said. Correct. Well, actually, it might be the issue. I don't know what he's fucking talking about. I don't know what he's talking about because of course that could be the issue. It just depends on what they discuss, how they discuss it, what those discussions entail. If she's influencing his decision, like that actually makes way more sense that the discussion between them would be of a critical nature. Because if she says, oh, that wasn't an insurrection, Donald Trump would never, he's the greatest. That's more influential than her just having general advocacy that she's done and he hasn't participated in. So I disagree with him saying that is not the issue. It's not the sole issue, but it is an issue. He says it's in the public domain that this case can implicate Ginny Thomas. in ways that are particularly important to her and thus derivatively important to Justice Thomas. That's not what ways? And this is one of those things that, again, this gets said flippantly by someone. As if it's true, we're just supposed to accept that there is something that can implicate Ginny Thomas in a way that's particularly important to her and Clarence Thomas. But what ways? The Supreme Court is not going to rule randomly that Ginny Thomas engaged in insurrection needs to be punished for it. There's nothing they're going to rule about Colorado or Maine's ability to determine whether or not a president can be kept off a ballot that involves Ginny Thomas. Nothing. He's just making shit up because ABC News won't ask any questions. Ginny Thomas's battle for conservative principles as a political consultant has stretched more than 30 years and distinguishes her from other Supreme Court spouses. Oh, of course it does. She's very special, right? She's super special, and we really need to make sure you all know that she's so special, because then if she's super special, then they can do this. But they have to come up with the problem that a lot of spouses of Supreme Court justices have had political opinions that align with the Supreme Court justice. And all of them are allowed to have political opinions. Supreme Court justices cannot publicly disclose those opinions, but they get to have them. Quote, I don't think there's any peer, frankly, in terms of the political activism of Ginny Thomas. She stands alone, said Roth, which doesn't mean anything. After the 2020 election, Thomas immediately engaged top Republican officials to fight the results, according to messages reviewed by ABC News. Yes. So, to then White House Chief of Staff Mark Meadows, she texted, help this great president stand firm, Mark. You're the leader with him who is standing for America's constitutional governance at the precipice. Very salacious. I mean, a little bit hyperbolic, but that isn't a scary text. That's not a problem text. Roth said, around the same time, dozens of emails obtained by congressional investigators showed Ginny Thomas wrote to Republican legislators in Wisconsin and Arizona, urging them to overturn the will of state voters. What does this have to do with an insurrection? Nothing. Even less than being at January 6th. Even less. That's the best part. Roth said Justice Thomas, at the very least, should offer an explanation of his decision not to recuse. Why? Quote, it's not sour grapes. Yeah. Okay. Viva Fry, my friend Viva, he always says confession through projection. So what people will project that which they hold, right? So here we go. Here's what we're going to see about the confession here. Quote, it's not sour grapes. It's not enmity. It's not racism. It's all three of those things. It's the fact that your wife wanted to overturn the election. So, and we have a lot of cases dealing with that insurrection. Tell us why you're not conflicted, he said. We have a lot of cases dealing with that insurrection. Huh. Audacity said, why is Pisco a good prosecutor but a bad lawyer? Oh, did I say that? I might have said that. That was a jab at Pisco because prosecutors have all the resources of the state, hold too many cards, have an imbalanced ability to do their job, and don't have to follow as many rules. That's what. No, you didn't, but it's inferred. Oh, well, yeah. That's why. Same reasons. It's all okay. I would have said that. All right. Ginny Thomas has not been charged with any crimes. Her attorney has said she fully cooperated with congressional investigators, and she's not named in their 845-page report on the Capitol attack. Still, a majority of Americans, 52% in a Quinnipiac University poll, believe Justice Thomas should sit out cases involving the 2020 election. Nearly as many, 47%, believe his wife's political activities pose a unique ethical problem. The Republican frontrunner Supreme Court appeal this week is likely not the only one the justices could soon hear with ties to fallout from the 2020 election. Trump is also fighting for absolute presidential immunity in the special counsel case against him over alleged election interference. Yes. Yes, he is. And he should, because now he's the first president indicted with a felony charge. They celebrated this so much, and the Supreme Court has to answer the question. They have to answer the question. This Clarence Thomas scenario related to January 6th and all the January 6th litigation coming so soon on the heels of the courts ostensibly adopting a code of conduct will, if nothing else, highlight the need for enforcement mechanisms to make the code meaningful, Sample said. Well, Sample, what constitutional means would you propose to enforce an ethics code adopted by the Supreme Court? What constitutional means would you do? Would you propose? I'll wait. Sample, you're an ethics expert, professor at Hofstra. I'll wait for your proposal. Who's going to enforce this? Who's going to do it? The court can't enforce on itself. Congress can. The House of Representatives can kick out members, right? The Supreme Court can't vote off a justice. They don't have any ability to do so. There's nothing there. So, what do you want them to do? How do you make it meaningful? You can't impose a code because their code is simply times of good behavior, and the solution is simply impeachment. That's all you got. But they're trying to impose this code, trying to make it meaningful. They want it enforceable, but there isn't a mechanism to do so. The existing mechanism of enforcement of any judicial code of any stripe is merely public perception of the court's integrity. And then the court justices' individual willingness to impact the integrity of the court one way or another. And you can't say to benefit the integrity of the court or uphold or maintain the integrity of the court, because they're going to have different opinions on what does that. Supreme Court justices are asked to answer hard questions, which is why the lifetime appointment applies. They're asked to be a political ballast against changing political ideas. That's why the lifetime appointment applies. They're asked all these things that are tough. If you just subject them to ethics rules that allow pressure to be exerted in the present by political activists on these justices to rule based on a current cultural zeitgeist or moment or movement, what you've done is compromised the Supreme Court's purpose, which is to balance out these conflicting ideas that are happening in the political side of the realm. Every appointment of a Supreme Court justice cements one of 9 at this point, 1/9 of the judicial will of the country for a long period of time. You would hope, because of their lifetime appointment, they would remain for 20, 30 years as a Supreme Court justice. And you cement that moment in time and that political ideology at that time. And it says, we're going to be the thing that holds all the political change back when it goes too far and too fast. But the Supreme Court is still human, and they're still political animals. They still operate on being liked. They still operate on popularity, book deals. All of those things still apply to these justices. So as they sit there, they will be impacted by changing political, legal environments. They will be impacted by the changing of ideas about various stuff. That's why ultimately the court does move along with society just a little slower, but that's intentional. That's how it was designed. So we'll have to see what happens. I don't think Thomas is not going to recuse himself. I think Trump is going to be found obviously qualified for the ballots in Colorado and Maine. I don't think they can allow states to do this. I've talked about it at length. So we're going to do next. We're going to move on from this. We're going to check a couple updates in the New York case. That's what we're going to do. Check a couple updates in the New York case. Trump lost this case a long time ago. The trial that occurred was merely over damages. We don't have the judgment on damages yet. Judge Engoron is expected to rule later this month on what the damages total is. Started with a request for $250 million. It's been upped to $370 million as a request from the prosecution. And there's some other stuff that's going on right now. I want to check that out in just a second here, because it's kind of interesting. So here we go. Let me pull this up real quick. So we got two avenues of pressure, and I'll pull them up one at a time. Well, one avenue of pressure we're talking about. This is kind of a remaining issue. Wait, that's not what I wanted to. Wait, what? That's not what the. Sorry, that's not the link I clicked on. Here we go. This is the link I clicked on. The fuck? Wait, what? Hold on. Okay. Sorry, this is a multi-part article. It's like a summary of multiple issues. So I thought I had the wrong article up. Here we go. So, Judge Engoron has determined that one of Trump's witnesses may have committed perjury. And so now they have to talk about it. This is a big update because this is a point of pressure, and this is an excuse for a higher award and potentially going after another person for a criminal charge. Because of course it is. Because perjury occurs in court cases all the time. But when you're aligned with Trump, your perjury matters more than anyone else. That's a rule. That's a rule that has happened. If it's Donald Trump related, the rule is all the other rules don't matter. All the other practices don't matter. They don't often go after perjury in court cases. They want people to be free to speak candidly, to speak honestly. And to go after perjury, they really want to be very, very sure that they intentionally lied about something. Because if you just prosecute every quote unquote perjury that happens in court, every misrepresentation or misstatement, then what you're going to do is not have witnesses say anything ever. So the judge gives lawyers Wednesday deadline to explain whether key Trump witness committed perjury. Judge Arthur Engoron, former Trump Organization CFO Alan Weisselberg, and New York Attorney General Letitia James are the key players here. Engoron set a Wednesday deadline of 5 p.m. Eastern for lawyers in the case to detail their knowledge of a New York Times report that Weisselberg had entered into negotiations with the Manhattan District Attorney to plead guilty to committing perjury on the witness stand during Trump's financial fraud trial, Bloomberg reported. Quote, I, of course, want to know whether Mr. Weisselberg is now changing his tune, whether he is admitting he lied under oath in my courtroom at this trial. Although the New York Times article focuses on the size of the Trump Tower penthouse, his testimony on other topics could also be called into question, Engoron wrote in a Monday email to the trial lawyers. Okay, so here's what happened. And Weisselberg, you should have waited out the judgment here. So what's happening is we're waiting on the judgment number. Now, Weisselberg is being accused of perjuring himself in the witness stand. Allegedly, he would have been charged or indicated that he would be charged with perjury, and he is trying to negotiate some sort of plea agreement, a guilty plea agreement. But if he pleads guilty to perjury from his testimony on the stand, the judge is going to take that into consideration when he renders his judgment. Say, wait a minute, this motherfucker lied to me. I was using this information to come up with my judgment number. Well, now he's going to use that information, or he's going to use that potential perjury to increase the number. I, of course, want to know whether Mr. Weisselberg is now changing his tune, blah, 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 blah. Wait, Weisselberg had testified on behalf of Trump and the other defendants that he never focused on the valuation of Trump's triplex apartment in Trump Tower, but that testimony was shown to be false. Engoron said in his email that he may find that none of Weisselberg's testimony during the case had been credible. If he does that, you can expect a maximum amount Weisselberg's apparent perjury negotiations are one possible reason Engeron is delayed issuing the final verdict in this case. Why it matters, Letitia James is asking him to find the defendant's $370 million in damages, issue a ban on the Trump organization doing business in the state. Weisselberg, who has already served prison time for tax fraud, was a key defense witness. If he pleads guilty to having lied under oath, it will further damage Trump's case. So, and this, of course, is the pressure and leverage. Hey, look, just plead guilty. You won't go to prison this time, or you get a really short prison sentence, or you'll do house arrest. Wasn't fun serving prison time, was it, Weisselberg? You want to go back? You want to go back to your boyfriend, Bubba? You want to do that? Maybe you should plead guilty to perjury. Maybe go ahead and do that, and then you don't go to prison, but Trump pays more. Good trade-off, right? This is just some of the shady shit that's been going on. I have one more thing that's out there. We're still waiting on the judgment on that case, right? It was supposed to be this month. Now it's later this month. We'll have to find out. I would expect a very high award. I would expect all of Trump's businesses be banned, all of his business licenses be revoked. I would expect an order confiscating some of the property to recoup the amount of money that he owes. And then I would expect an appeal on all of it. Here's another interesting thing that I kind of talked about before from this same trial. If you guys remember, there was a gag order on Donald Trump. There's a gag order on Donald Trump talking about the clerk in this case. The clerk in this case sat right next to Judge Engeron, which is weird. But there are cameras. And one of the things I suggested is that this court clerk, I wasn't the only one, by the way, this court clerk that Donald Trump was talking about on social media, has a motive to be involved in these cases that have cameras and high profile, because all of these people have political motive and aspirations. Well, looky fucking dookie at this. Looky dookie? That's not a thing. Trump attacked her as a co-judge. Now, New York law clerk Allison Greenfield is on her way to becoming an actual judge. No fucking kidding. You don't say. Here we go. Let's see. Former President Donald Trump has attacked her as a biased co-judge, claiming she secretly runs the show at his New York civil fraud trial. But now the principal law clerk is well on her way to becoming a judge in her own right. Her own right. Nothing to do with this. Greenfield is running to be civil justice in the state Supreme Court in Manhattan, just like Arthur Engeron, the fraud trial judge she so famously clerks for. So famous. And from whom Trump is awaiting what could be a corporation crippling verdict. Last week, Greenfield cleared the biggest hurdle, Manhattan civil judgeship, when local Democratic Party leaders rated her most highly qualified. Do you know how hard it is to campaign as a judge? There are so many rules on this. It is hard to campaign as a judge. You're restricted in what you spend and what you say and what you do. But if other people say stuff about you, if other people rate you well, oh my goodness, that's fine. Panel has spoken. The results of the 2024 Civil Court Independent Judicial Screening Panel. Yeah, because everybody pays attention to that. The next big step happens on Monday. That's when Democratic district leaders are expected to nominate Greenfield as the unopposed Democratic candidate for the judgeship on the November ballot. Oh, she's unopposed? Why? I think other people are told, maybe you don't run. Maybe you don't run. Oops, hold on. She appears to be backing in high places. Now, the borough's top Democrat, Manhattan Borough President Mark Levine, touted her qualifications success on Threads. Quote, the trial clerk in Trump's civil fraud trial, Allison Greenfield, has been viciously targeted by the MAGA crowd with vile rhetoric and death threats, Levine wrote. Plot twist, now she's taking a major step toward becoming a civil court judge herself. Last week's screening panel success was likewise enthusiastically welcomed. Greenfield drew the biggest round of applause in the room when the New York County Democratic Committee announced the names of all 10 candidates who qualified for judgeships throughout Manhattan. Our town reported of the Thursday vote. The vote to qualify Greenfield was first reported by Law 360, which noted that the city's Democratic Party machine effectively selected the judicial candidates who would be on the party's ballot lines in each borough. Democratic candidates for judgeships often run unopposed in the city of few Republicans. Judges serve 14-year terms and then must seek re-election. Oh, my God. High profile in a high stakes case. Greenfield and Engeron have sat side by side as clerk and judge. Come, Tonto. For more than 2 years of hearing and trial dates, as New York officials and Trump have warred over the fraud case, where a verdict is expected in the next 2 weeks. New York Attorney General Letitia James has alleged Trump fraudulently inflated his wealth by as much as $3.6 billion a year in a decade's worth of annual net worth statements he used to win $168 million in loan interest savings. Trump has countered that no fraud was committed and that his valuations were conservatively low. Lawyers for his co-defendants in the lawsuit, the Trump Organization, his sons, Donald Trump Jr. and Eric Trump, and his longtime company executives, Alan Weisselberg and Jeffrey McConney, have also denied wrongdoing. Engeron is yet to determine a final penalty, but has so far sided with the Attorney General, finding that even pre-trial, there was ample proof of billions of dollars in fraudulent annual valuations. Oh, yeah, of course he did. Greenfield has been visibly active participant in the case, often conferring with the judge during public proceedings. When the judge speaks, you have to stop speaking, Greenfield told Trump's attorney, Alina Habba, during a 2022 pretrial hearing. That's not her job, by the way, except if you're trying to raise her profile. All of this is, we're not going to go any further on this. We don't need to read the rest of it. Look, the whole thing that I want to get across is in all of these cases, these judges, these law clerks, these prosecutors, everybody, these are the highest profile cases in the world. Everybody stands to gain from them politically if they're political animals. Now, lawyers aren't always political animals. They may stand to raise their personal profile, their firm's profile, increase their income, but it's still based on the work that they do privately. These government weasels and rats raise their political profile to get appointed or elected to various positions that they can't really influence as much on their own. Finding ways to get notoriety as a judicial candidate is critical to getting your name out there against anybody else. Her clerkship here, Donald Trump has attacked her, sure, because he claims she's biased, because she is. Her clerkship here, in this case alone, is what's getting her this nomination. That's it. She's going to run unopposed. She's going to win. She's been hand-selected, groomed even, by Democrat Party leaders because of her participation in this case and how she's done it. That's it. That's what's done it. And man, to me, that sounds like an appearance of impropriety, but hey, who am I? Rice says, how are you, Nick? I'm doing well, I guess. Pretty good on balance. I have up days and down days, but generally great, man. Thanks. Audacity says, why isn't Engeron's obvious bias called into question for this case? Oh, it has been. It'll be in the appeal as well. They just have to wait for the final order or the final judgment to come out before they can appeal it. Why do we have to wait for appeals in New York? It's everywhere, which also has a high chance for bias. Why the fuck is there no audit or oversight for bias? Well, the audit and oversight is the appeal. You just have to wait for the final order unless the appellate issue is uniquely situated to end a case completely. Otherwise, you just have to wait for the final resolution because they want to use judicial economy. All of the appeals issues need to come in at once. If you're able to appeal at every single issue, you're going to have 50 appeals per case. Not efficient. If there is an appeal that specifically can foreclose every other issue by itself, that one can be appealed during the pendency of the case. Otherwise, all the appeals wait for the end. And that's going to come here. Obviously, Trump's going to appeal this. The bias of the judge, the rulings of the judge, the actions of the law clerk, his public profile, they'll be raised. Will they be relevant? We don't know. I doubt it. I doubt the appeals court's going to do anything about it. So, all right, guys. We're at an hour in. We've covered the topics I wanted to cover today. I do need to get going. As stated early on the show, this is going to be a short stream, about an hour long. I got to get some rest. I love you all. Thank you for watching. Thank you for the super chats. Thanks for the attention. I will be back. Should be a full stream tomorrow, 11 p.m. Central, normal time. We'll see you guys then. Until next time, have a good night. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an Ardbeg, a Balmore, a Lafroig. The spirits blow as the ones who get unemployed. So pour out a glass for the tea post on Twitter, as we hear law-splaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all plentiful, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the tea post on Twitter, as we hear law-splaining tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have.